Colleagues, it's time for us to start, and we've also formed a quorum. Please invite the officials to come in. The last meeting was held on the 29th of October, which we had a public hearing. We listened to the views of the deputations and members of the industry. The administration has prepared a paper in response. It's paper 285-02. In a moment, we'll invite the officials to explain the paper to us. After studying the paper, if there are no further follow-up questions, we can start with clause-by-clause scrutiny. Welcome. In attendance today, we have Mr. Andrew Lai, Deputy Director of Environmental Protection, Mr. Samson Lai, Assistant Director of Environmental Protection for Waste Management Policy, Mr. Simon Hui, Principal Environmental Protection Officer, and Mr. Peter Zi, Senior Government Counsel from the Department of Justice. Mr. Lai, would you please explain paper 285-02 to us? I suggest we go through the questions and answers one by one, rather than going through the whole paper in one go. So we'll take the questions and answers one by one. Mr. Lai? This paper is to address follow-up questions and issues raised by members at the last two meetings. For question one, the question one is about the town planning ordinance in combating fly tipping activities. The planning department told us that in relation to the town planning ordinance, if interim development permission area plans or development permission area plans are involved, they will enforce the law against fly tipping by way of the ordinance. As regards the construction and demolition materials, they have new methods to prevent applicants from establishing facts in order to launch development plans. Illegal activities and their information are set out in Annex A. Or Annex B, Mr. Lai? Is it Annex B? Is it Annex A or Annex B? Annex A, all right. Mr. Chen Hangpan. Thank you, Madam Chairman. I can see that the number of complaints has been rising in the past few years. As for the number of summonses issued, is relatively few. Why so few? Is it that they failed to arrest the people concerned? Thank you, Mr. Chan. This involves law enforcement under the town planning ordinance. The department responsible is the planning department, and we obtained this information from them, so we do not have first-hand information here. As for the waste disposal ordinance, our department also had law enforcement experience. Public complaints may be different in number from the number of summonses. Why such a discrepancy? There may be a number of reasons. First of all, complaints may be repeatedly about the same case. Say dozens of members of the public observe illegal filling activities at the same location. They all complain, but in fact those complaints involve just one case. This has led to the discrepancy. Secondly, for the summonses, for the issuance of summonses, we have to go through established procedures. We have to see whether there's sufficient evidence and information to allow the DOJ to take out a prosecution. In that process, whether or not suspects can be found and whether or not evidence is sufficient to warrant the issuance of summonses will have to be considered by the law enforcement authorities concerned. So this is a difficulty facing us in combating fly tipping activities. So there are discrepancies between the two sets of figures, that is for prosecution and for summonses. We'll try to understand this with the planning department after the meeting. Mr. Chan, you mentioned the enforcement of the town planning ordinance. However, NXC sets out prosecution statistics for Section 16A of the Waste Disposal Ordinance. Very few, just a few dozens per year. In the urban areas, be it dumping or illegal landfilling, there are huge discrepancies between the two sets of figures. Do you have difficulties in law enforcement? Or is it because you're unable to find evidence or you can't even identify the culprit? If that's the case, will you consider amending the ordinance? Thank you, Mr. Chan. I think Mr. Chan's remarks have actually explained most of the difficulties we encounter in law enforcement. At present, if we want to successfully take out prosecution against a certain case, we more or less have to catch the person red-handed. Say if a person is actually dumping wastes and is witnessed by our colleagues, or unless we have CCTVs to monitor dumping black spots, or unless we have very specific information to allow us to master the breach itself, it will not be possible for us to follow up on particular cases. For example, if we observe from the CCTVs that in the vicinity of Sha Tin, people are dumping these demolition and construction wastes, then first of all we have to see the number plate of the vehicle concerned first. And then we have to go to the scene to see who's doing that, because it may not be the driver of the truck doing the dumping. So our colleagues must have sufficient information and evidence before prosecution can be taken out. So that's the first difficulty. The second difficulty is like this. Section 16A of the Waste Disposal Ordinance stipulates that if the dumper has obtained consent from the site occupier or the landlord, the dumping will be lawful. But precisely of this stipulation, in the past when we'd like to take out prosecution against breaches, we discovered that many private lots in the new territories might be owned by more than one owner. Maybe a Zhoutang site is owned by 10 owners. And if consent has been obtained from one of the owners, that can constitute a defense, such that we cannot trigger the prosecution process. It's precisely because of this that we would like to stipulate that consent from all owners of the site had to be obtained, and there must be a signed declaration in order that we can regulate these illegal activities that will help with prosecution in future. Mr. Chan asked a very specific question. If the new proposals are implemented, it will be easier and more objective for us to take out prosecution. But still, the whole new territories is so vast in area. There are so many dumping spots. Will it be possible for us to arrest the person and gather sufficient evidence for prosecution? That may even be difficult still. Colleagues Just now we did not have that many colleagues. Now more colleagues have arrived. So just now I allowed a longer duration for questions and answers. And this bill is not that controversial. But as we have more members in the room now, I will ask the clerk to put on record the speaking time. There's plenty of time, actually. Mr. Chan Hak-kan, Madam Chairman, I'll be very concise and precise. I'm also interested in the figures in Annex A. Now, these are annual figures. There are no breakdowns for different regions. Of course, we focus our attention on illegal dumping in the new territories. In the last session, Dr. Chang Lai-wan asked a question, I forgot whether it's oral or written, question about unlawful dumping of debris in the new territories. The situation was serious. I also received 2 cases. Where are they? They might not be on the main streets in the Western District or Charcoal Lane, where there are not that many people. Trucks very often dump debris at certain locations. Mr. Lai, can you give us some breakdowns? You don't need to give us too old figures, say for 2012, 2013, for Hong Kong, Kowloon, and the new territories. What are the breakdowns? And of course, we're focusing our attention on the new territories. Part of the problem has been solved, but in the urban areas, there are gray areas. In future, people won't dump the debris in the new territories. They'll go to maybe the back lanes of the Western District, and then we may need to have another amendment exercise in order to plug the loopholes. So do you have figures in that regard? Say in the urban areas, how are you going to plug the loophole? And in this amendment exercise, can we plug the loopholes? May I add one point, if Mr. Chan does not mind? In the past, we have cages to collect old clothing. They're everywhere on our streets. There are no laws to regulate them. And Mrs. Rita Fan and the CS4 administration set up an interdepartmental working group to handle the problem. And now they will post a slip of paper on the cage for 24 hours. But of course, they will come back in 24 hours' time. Mr. Lai, concerning Mr. Chan's question, I have some figures here for your reference. But of course, these are just short-term figures, or figures collected during a very short period of time. We do not have the latest figures from the planning department. For EPD, for the first half of 2013, number of prosecutions, altogether 27 for the whole of Hong Kong, 27 prosecutions. 11 in the new territories, and the remaining 16 occurred in Kowloon. For the first half of this year, there was no prosecution on Hong Kong Island. So, dumping and fly tipping do occur in the new territories as well as the urban areas. But the scenarios may be different. For the urban areas, our colleagues' experience is that the volume or quantity collected was rather small, usually related to the renovation works of buildings.
In those cases, if we are to enforce the law, then we'll see that the construction waste is in small quantity, and then we will use the fixed penalty ticket to directly prosecute the offenders, $1,500. But for the NT, what members are most concerned is about dumping in large area of land on private agricultural plots. And that's exactly what we want to, where we want to plug the loopholes on with the latest amendment exercise. Thank you, Chairman. Madam Chair. Mr. Lai's figures are very clear, and that goes to show that what I said, that the illegal dumping takes place also in the urban areas and not just in the NT. Well, no case in Hong Kong Island, is that right? Well, the number may not be too big in the past couple of years. Well, of the 27 cases, 17 of them are in Kowloon. So it shows that the problem is serious in Kowloon. So I hope that the government can consider afresh what I suggested. And we would not have to tackle the problem in Kowloon in the future. Let's do it in one go. Mr. Lai has given us a very clear picture about the waste from repair works undertaken in Kowloon, which caused the construction or generate the construction waste. I hope that you can understand that illegal dumping of construction materials is a territory-wide problem, but it's just that the causes of the problem in NT and the urban areas are different. So through the colleagues in our divisional offices will check on or follow up on the cases through surprise checks and inspections. But in the latest amendment exercise, we target to make it more convenient to collect evidence for illegal dumping in the NT, and we will try to make it more deterrent for the offenders. Now, for illegal dumping in the urban areas, the fine is only $1,500. But for the offenders in the new territories, the maximum penalty is $200,000 in fine and 6 months imprisonment. So that's not very fair. I have also a question to raise. When the bill is passed, the landowners will agree to post a notice. And I think this requirement can also apply to the urban areas. The land in the urban areas belongs to the government, and you have to tell us why a heavier penalty is handed down on offenders in the NT, whereas the fine for offenders in the urban areas is only $1,500. Well, can you go back and think about the rationale behind? Well, please allow me to tackle this question. There are two types of illegal dumping in terms of the land. One is government land and the other is private lot. In the urban areas beside pedestrian walks or roads are normally government land. So the land title is relatively clear. For example, in Nathan Road or other roads in the Kowloon, if you dump construction waste beside these roads, and 90% of those plots will belong to the government. In the NT, the problem is more complicated because the NT is vast in territory and some are remote areas, and people would like to more likely to take the risk, and it also involves multiple land ownership. So that's why we want to tackle this problem through this amendment bill. Perhaps I have not made myself clear. There are two mechanisms for prosecution. If the dumping quantity is small, is it 0.2 cubic meters or below? It's just, say, 1 or 2 packets of construction waste. We would issue a fixed penalty ticket to the offenders, fining them a fine of $1,500. So that is based on the quantity of the construction waste dumped. In the urban areas, we'll find it easy to catch the offenders because there are always those carrying out repair works in old buildings. And if we find the same situations in the same scenario in the NT, we would tackle it in the same way as we do in urban areas. And the second scenario is we do it through the waste disposal ordinance. Again, the maximum penalty is $200,000 and then 6 months imprisonment. Usually, a larger quantity of construction waste is involved, and it covers a larger area. Say in this latest amendment bill exercise, we will tackle those occupying an area of over 20 square meters. In 2013, in the first 6 months, we issued 83 fixed penalty tickets, and 1/3 is in NT and 2/3 are in urban areas. And because there is a larger population in the urban areas, it's easier for us to catch the offenders. But it doesn't mean that we are turning a blind eye to the problem in the NT. Mr. Wu Chi-wai. Thank you, Madam Chair. I have 2 points to raise. I have heard Mr. Lai's explanation. My question is, so if the quantity of waste is between 0.2 cubic meters to 20 cubic meters, what are you going to do with cases like those? Secondly, the Transport Department will look at any photos taken by the public about, say, speeding. Will deal with those cases. Now, say in the present scenario, if a member of the public takes a photo of a dump truck drivers dumping the construction waste and handing the photo to you, would you accept that as evidence, or do you want to have to collect evidence yourself? Well, thank you, Mr. Wu, for your 2 questions about the prosecution. To my understanding, well, perhaps Mr. Hui can talk about the actual experience later. My understanding is that the prosecution will be initiated by colleagues from the EPD and the DOJ. But as far as collection of evidence is concerned, we would depend on a large number different parties to do that. Now, the EPD will catch people red-handed on site, but if there are members of the public who provide us with photos of illegal dumping or videotapes of such activities and enable us to follow up on the cases, then that will help us in our prosecution work. But as to whether the evidence can be submitted, then it depends on the actual cases. And we'll have to discuss with those collecting the evidence further. Now, as for the quantity of the waste, for the fixed penalty ticket, it is targeted at weight of a smaller quantity. Say 2 packets of construction waste dumped on the roadside, we will deal with it by the way of the fixed penalty ticket. But for waste of a larger quantity, say a quantity which exceeds the level covered by the fixed penalty ticket system, we will initiate prosecutions. Well, we will initiate prosecutions of waste of a relatively large quantity. Now, for the amendment bill, there is this additional requirement. Now, if this private lot is used for accommodating the waste, and if the lot is of an area smaller than 20 square meters, then it will fall outside the amendment bill. But it doesn't mean that there is an exemption mechanism. It doesn't mean that a small quantity, for a small quantity of waste, we will not deal with it. That's not the case. For unauthorized dumping, it is already an offense. But we will see, or we will take on board the amount to see whether we should resort to the fixed penalty ticket system or prosecution system. Perhaps on the law enforcement, Mr. Hui, can you add or supplement? Thank you, Madam Chair. Mr. Wu's question, yes, my answer is affirmative. If members of the public can provide us with evidence, we can follow up duly and initiate prosecution. In the past, actually, we have had successful cases whereby members of the public have provided us with evidence, and we have initiated prosecution. Mr. Lai, can you be clearer? Say if the quantity is small, say less than 0.2 cubic meters, then a fine of $1,500 will be fined. Now, if the quantity is larger, then it will be covered by the amendment bill. Is that right? Okay, Madam Chair, we can take a wider perspective for handling illegal or unauthorized waste dumping. As we said in past meetings, there are different pieces of legislation enforced by different government departments. For EBD, we will resort to both the fixed penalty ticket system and also a prosecution system, and we will resort to different ways depending on the different circumstances of the case. For example, in the plastic bag levy, the fixed penalty ticket system will be used, and there are preconditions if we are to resort to the summary offences ordinance. Say, if you litter, then it will be covered by summary offences ordinance. We set the threshold at 0.2 cubic meters for the summary offences ordinance. For waste of a quantity less than 0.2 cubic meters, it doesn't mean that it is not an offence, but we chose it to cover it by another ordinance. We have 16B and we have 16A. Irrespective of the quantity, the waste will be subject to Section 16A. It's just that we have problems in enforcing the legislation as far as 16A is concerned. So that's why we added in 16B to strengthen the control. And the public consultation exercise, we mentioned that the quantity should be of a reasonable amount, because some of the construction waste can be recycled for you to be put into good use, say the sand and rock and so on. So if the quantity is not too big, then it will still be covered under Section 16A. Last time, some deputations mentioned about 20 square meters. It equals roughly to 1.5 truckloads of vehicles. Well, this we can further discuss. We think that a 20 square meters permitted area is reasonable. But then for area under that size, it is still covered under Section 16A. Well, if no further questions, then we will go to question 2A. The structures on private lot. In this amendment bill, we target depositing of waste in private lots. In the last meeting, some members are concerned that would the amendment bill cover buildings or structures on private lots or dilapidated buildings on private lots. The amendment bill really aims at illegal dumping on vacant ground, and it doesn't cover buildings or structures. I hope that members can appreciate that if there is illegal dumping of waste, let's take the easier route. Or people would rather take an easier route, and i.e. people would rather dump the waste on the ground instead of or in the buildings on vacant grounds. So the possibility of dumping within the building is rather remote.
B 啦，就係關。
All right, and then EB, dilapidated village houses. Well, this is related to the last reply. If we're talking about a dilapidated structure, we really have to look at the actual circumstances surrounding that structure. Usually we deal with wastes dumped on the ground. If a structure is totally dilapidated, it will be difficult to define whether or not it's still a structure or a pile of wastes on the ground. Legal advisor? Madam Chairman, in paragraph 4 of the paper, it is said that the Waste Disposal Ordinance does not mention structure. In fact, the ordinance does mention structure. So, would you like to clarify? DOJ representative? Can the legal advisor elaborate? In poultry farms, there is mention of structure, and also in Schedule 10, structure is also mentioned. I think the focus of the department's response is that there is no definition in the ordinance. I'd like to thank your legal advisor in raising the point that the term structure can be found in certain provisions, but then there's no specific definition under the ordinance, the Waste Disposal Ordinance. So it's not found in the Waste Disposal Ordinance only. Any follow-up on 2B? I have to remind members that if we only have the chairman present, I'll declare the meeting adjourned. Question 2C. Question 2C. Definition for a private lot. Two conditions have to be satisfied before a lot will be considered as a private lot. Members, if you don't have questions, we'll move on to question 3. What factors will you consider in taking out a prosecution? Mr. Lai? It depends on what's happening at the time of the offense. In particular, whether all owners of the site or consent from all owners of the site has been obtained under the new Section 16b(3). If we maintain the existing Section 16a(1), then consent has to be obtained from the landowner or his authorized person. No questions? Then we move on to question 4, conspicuous place. Indeed, there's no legal definition for conspicuous place in the ordinance. It's very difficult to define a conspicuous place. Let me cite the New Territories as an example. If a private lot is in open air, if a notice is put up, then it should be deemed to be a conspicuous place. Because if you're not talking about a structure, you're not talking about an office, then you cannot specify whether the notice should be put up on the door or somewhere else. the licensee or the person responsible has to put up a notice even on an outdoor premises. All right, if members don't have questions, we'll move on to question 5. Who are the empowered public officers? Maybe I should defer to Mr. Lai. At the second meeting, there was this discussion on a number of cases with people engaged in fly tipping exercises or activities, but when police officers arrived at the scene, they're unable to do anything. So here, we try to set out the law enforcement process. So, under the existing provisions, a certain act may not be unlawful, but if the new 16B is enacted, such acts may become unlawful. Even with the presence of the police to provide assistance, the EPD will remain the law enforcers. So, EPD officers have to be present. Paragraph 11 informs members what powers we have under the existing ordinance. Paragraph 12 mentions what improvements will be attained after the amendment bill is enacted. Anyway, for illegal fly tipping activities, when our colleagues arrive on the scene, they can check relevant documents to see whether or not the relevant approval has already been obtained. Otherwise, the activities may have breached Section 16B and prosecution can be taken out. Last time when we raised this, the context is if EPD officers find it impossible to enforce the law, they'll call the police for assistance. For the new 16B, if law enforcers are prevented from enforcing the law, there may be an offense. Of course, you're talking about EPD officers under authorization. And under what circumstances will Section 23F be breached? Well, under the amendment bill, new powers will be given to us to allow us to ask for the production of the form. Failure to produce the form can constitute an offense. Well, you said you're unable to define conspicuous place. Anyway, where the wastes are found, you can erect a notice. If the authorized officer is unable to find the authorization documents, and if the person concerned fails or refuses to produce the documents, then he can be prosecuted under 2 offenses. Madam Chairman, it depends on the facts of the case. Both provisions may be breached under the circumstances mentioned by you, and such cases will be referred to the DOJ for consideration. Now, if I catch the person red-handed, do I have any power to stop him from dumping the wastes? All right, the EPD officers arrive at the scene, the police is called in to provide assistance. If the person still continue with fly tipping or dumping, can the police officers at the scene immediately arrest him? particularly when the second truck of debris is coming. Our past experience tells us that we will always have police officers to assist us. If we can give a clear recommendation to the police, and if it is clear that the person on the scene has clearly breached the law, the police officers will take action. You mean including arresting him such that he cannot continue with his fly tipping action? Right. Members, any questions? If not, we move on to follow-ups from the third meeting. Mr. Lai, would you please explain to us? You can do this in one go. Paragraphs 13 to 16 mainly explain under the new provisions who will be targeted. Basically, two categories of persons. People dumping on private lots without proper consent. Second category persons employing drivers to do dumping. So the person behind the scene can also be prosecuted. As regards prosecution figures and fine, in the past years you can find them in Annex C. It's worth noting that in the past 2 years, the court has been increasing the level of fine. Is a rising trend. Any follow-up? At the last meeting, the deputations told us that 20 square meter is more than one truck. If a person employs 2 drivers, 1 per truck, the first carries less than 20 square meters, and the second truck carries more than 20 square meters. So, who will be prosecuted? The same person employs the 2 drivers. The first driver can get off the hook. The second truck carries more than 20 square meters. But if you add the 2 truckloads together, the threshold will be exceeded. Well, Madam Chairman, we did have borderline cases. For illegal fly tipping, very seldom do we see a whole fleet of trucks engaging in such behavior. So I wonder whether we'll see cases of many lorries involved. 20 square meters is a reasonable threshold arrived at previously upon consensus. Irrespective of whether or not we're to adjust the figure 20, theoretically what the chairman depicted just now might happen. In fact, 2 truckloads will exceed the threshold. Of course, 2 trucks will be more conspicuous than 1. Now, if 2 trucks come along, the first truck driver is not prosecuted, but the second one, that's not fair.
Mr. Hui, thank you, Chairman. In the past, there have been seldom cases of a fleet of trucks doing fly tipping. Without proper authorization, these fly tipping activities are subject to 16A. Well, even for the first truck, it is still breaching the law. if permission has not been given, if 20 square meters is specified in 16B, and that is a requirement, and if the waste covers an area less than 20 square meters, prior permission is not needed from the EPD, and they don't have to display the acknowledgement either. What's most important is that the trade finds the amendment bill fair, and the law should treat both trucks fairly. All right, so much for this particular document. Policy direction, any follow-up from members? If not, then we can go to the clause-by-clause scrutiny stage. I would suggest that members look at the marked-up copy and the blue bill. Then that will make the documents complete. All right, marked-up copy. Paper number CB 11505 12 to 13 bracket 02, and then the blue bill together. Yes, Mr. Lai, would you help take us through the paper? Well, perhaps I'll defer to Sampson to take us through the marked up copy. The first clause is about the commencement date. As provided or stated in the previous document, we will be specifying the commencement date later. After the bill is passed, we would be doing some publicity work among the stakeholders and the landowners, and we would hope to bring the commencement, to set the commencement date 3 months after the bill is passed. What are you going to do as far as publicity is concerned? We would, through our regional offices to do publicity work, we would work with the Hung Yi Kok also. During the public consultation period, we had worked together with the Hung Yi Kok. In the public hearing session in the last meeting, we have a constant dialogue with members of the trade, so we would continue to have a dialogue with them. You will be presenting the commencement date later in the bill later on, right? Yes, any questions? Well, it's interpretation, clause 3. We would add in the definition of private lot. In the previous panel meetings, we have elaborated on what is meant by private lot. This time round, we have also provided further information on why private lot is defined the way we did. So any comments from members? Anything from you, legal advisor? No? Then we can go to the marked up copy. Let's turn to page 5 of the marked up copy. Mr. Lai. Clause 5 relates to the addition of 2 new sections, 16B and 16C. 16B talks about the scope covered. We have 2 exemption clauses which relate to 16B, but then these exemption situations are covered under 16A also. And it has to do with the total area of the depositing of waste. And then 16B also talks about the building works carried out in accordance with certain existing pieces of legislation, and they are not the sources of fly tipping, so that will also be exempted. And when we in subsection 2, in calculating the total area for subsection 1A, waste containing both construction waste and other waste is regarded as consisting entirely of construction waste. 3. has to do with the main substance or the gist of the amendment bill. If a person who deposits construction waste on a private lot without the valid permission of the sole owner or all of the owners of the lot commits an offense. In subsequent clauses, we also talk about how permission should be obtained. All right, subsection 4. It says that the specified form or a form specified by the director should be used, and also there should be an acknowledgement affixed by the director in accordance with certain procedures. Subsection 5 has to do with the sole owner. If, say, the sole owner is involved in the depositing activity, so he doesn't have to obtain a permission from himself per se. So the subsection 3 does not include the owner. Does it mean that if he is the sole owner of that lot, he can do whatever he likes with the land? Say, if in country parks, well, actually we've scrutinized a country park bill. Now, if a certain person buys a piece of land and then he undertakes certain activities in that piece of land, do you have sufficient legislation to regulate him? Yes. Okay, we have to look at whether the construction works are carried out in accordance with the buildings ordinances in Schedule 13. That has to be considered. Any follow-up? All right, 16, subsection 6. It talks about section 16A, 2, 3, 4, 5, and 6 applying in relation to an offense under subsection 3. And 16A, 2 to 6 have to do with existing regulations, and they are also applicable or covered under 16B. So that's why we have included subsection 6. All right, let's move on to 16C. It deals with the specified form. The permission has to be given in written form. And in subsection 2, it says the director may specify a form in which the permission is to be given. And the director can also require certain information to be furnished to him so that he can consider this information in affixing the acknowledgement. Now, subsection 3 deals with the procedures of the acknowledgement. It has to be, the information of form has to be submitted prior to the depositing activity, at least 21 days before the intended date of the depositing activity. All right, when you submit the subsidiary legislation to us, please provide us with the forms as well. B says that upon receipt of the form, the director will check with the land register kept under the Land Registration Ordinance to see if the owners are really those in the register. If there is any irregularity, this means then the procedure is not proper, or the register's information is not updated. If this is the case, we will stop processing the acknowledgement. We'll wait until the applicant has clarified who the true owners are. The records have to be duly amended or clarified before the director will proceed with the acknowledgement procedure. If everything is in order and the director is satisfied that the permission is given by all of the owners, then the director will affix the acknowledgement on the form. It doesn't mean that the director has the authority to approve the depositing activity. The depositing activity has to abide by other relevant pieces of legislation like the town planning ordinance and so on. All right, subsection 4 says that the form must be displayed in a conspicuous place. Subsection 5 says that the form may contain a lot of the information like personal information and so on. Not all the information has to be displayed. Only certain parts have to be displayed. Well, the purpose is really for the public to see that the depositing activity is carried out with due permission. So no excessive information should be displayed. Subsection 6 deals with that fact that the information furnished should not be incorrect or inaccurate. Such a requirement is also contained in other similar pieces of legislation. Subsection 7 talks about the offense. So if the form is not displayed, the person commits an offense. So then we have the different offenses. Clause 5 has to do with amending sections 18. It's amendments to do with the headings, the illegal dumping activity in 16B will be viewed together with 16A. For the first offense, a maximum fine of $200,000 and jail term of 6 months will be imposed. And the same maximum penalty applies to both Section 16A and 16B. And the continual offense each day, $10,000. Yes, it remains here. Yes. About the new offenses, about the provision of information and display of the forms. And when we look at the seriousness of the offense, then we set it at level 6 in terms of the fine. Clause 5 has to do with the addition of 16B. And it will be the same treatment, subject to the same treatment as 16A.
What about safety in waste disposal? Well, if a person allows an amount of wastes to be left somewhere, public safety and public health may be affected. So the department may have to take proactive action to clear the wastes. I don't understand. This is a defense clause. I don't understand because this is a defense clause. I cannot imagine any scenario in which wastes have to be dumped on a private lot on the consideration of public safety. Well, if you are concerned about public safety, you should find experts or somebody else to clear the wastes as soon as possible. Well, Madam Chairman, this is to allow it to be in line with 16A. We can go back and further consider the situation of construction wastes, because the definition of construction waste is rather broad. Is any waste generated on any construction site? It may not just be debris or mud. There may be other types of wastes. Under the existing 16A, we already have such a provision. That's why we'd like to model on 26A. Mr. Kenneth Chan, I think they have to offer a clearer explanation. It has nothing to do with the definition of waste. I think emergency, hazard to public safety, etc. should be defined. Well, I can think of rescue operations in disasters, emergencies, say if a factory explodes, firemen or whoever participating in the rescue operation may place certain waste somewhere in a hasty condition. So I'm turning this into a question to see whether or not you have such scenarios in mind. Anyway, in this scrutiny exercise, you have to clearly define that. Otherwise, people will always tell you is emergency, is for public safety, etc., etc. Well, thank you, Mr. Kenneth Chan, for assisting me in following up on this question. I think you really have to tell us under what circumstances will exemption be granted. And you do have a time frame here. You require a notice to be put up in advance. So under what circumstances will you grant exemption? Madam Chairman, in 18(2), there's no definition of an emergency. But if you look at 16A and 16B together, you see that there are contents in both sections that permission has to be obtained. So by emergency, we're saying that the person concerned finds it impossible to get a permission. So Mr. Kenneth Chan mentions one possible scenario, say in a rescue operation during a disaster. I think we need to look at the circumstances involved. Well, rescue operations may be one scenario. Whether or not the wastes are hazardous will also be another consideration. I think the authority will consider whether or not this provision is satisfied. I think we all understand that under certain circumstances, the procedures may not be complete out of consideration for public interest or public safety. But you must not ask councillors or electoral members to think of all these scenarios, special scenarios for you. What we're saying is that you should not allow any person to use this as an excuse to get exempted. We'll definitely ask questions. You definitely have to provide answers. So in future, if this exemption is to be granted, we'll be able to dig out records about the conditions for granting exemption. So the government has to think about this very thoroughly. Don't wait for questions from us. Chairman, I'd like to thank you for the explanation, which is totally correct. Well, there may be unforeseeable circumstances. We cannot set them out one by one comprehensively. We cannot exhaust the list. Let me cite a specific example. Say, Section 16B is mainly about dumping on private lots. To be lawful, the dumper has to obtain consent from all owners and permission from the EPD has to be obtained at the same time. Well, Mr. Kenneth Chan mentioned a natural disaster. Say if Shenzhen River is flooding, we have to transport soil and mud to place sandbags along the water banks, etc., etc. Well, we may not have obtained consent from all the owners. We may not be able to obtain permission 21 days in advance. Anyway, what we're saying is that for the sake of public safety and without affecting the public, exemption can be granted. The government cannot breach the law. If there's no exemption provisions and we cannot follow the procedures, in special circumstances, we may be in trouble. We may be breaching the law. Does this ordinance bind the government as well? Is this confirmed? I don't want you to tell me in future that public officers are not bound by statutory provisions. Please continue. Chairman, we're now on clause 6 in relation to authorization. In subclause 3, a new power is to be added in relation to the vetting of forms. Just now members asked, what if the person refuses to produce the form? So this is the provision. So again, it will be the EPD officers, right? Yes. All right, please proceed to 23EA. Yes, Chairman, Clause 7 is to amend Section 23EA in relation to the Director's power to remove waste in case of imminent risk of adverse environmental impact. This is the same in 16A. We believe that this should be included in 16B as well. All right, then Section 31 of the Principal Ordinance, which is to be amended. Chairman, Clause 8 is to amend Section 31 of the Ordinance in relation to mental ingredients of certain offences. 16A covers very serious criminal liability. Earlier, the legal advisor asked us certain questions. The amendment bill suggests that the same should be done for 16B. But the legal advisor mentioned 16C7. We answered, given the nature of 16C7, which is regulatory in nature, it should be covered. So the best solution is to write it in a clearer manner. If members do not object, we suggest that the administration moves a CSA to clarify the position. So thank you very much for listening to our advice. Next, Chairman, Clause 9 sets out the amendment for the amendment of schedules. The Director will, by way of a notice, make the amendment, and the specifics are in Section 10. Two provisions in the Buildings Ordinance. That is, works commencing under the two ordinances, that is CAP 121 and CAP 123, the works will not be affected. Any question? If not, we can move on. Chairman, we have completed clause-by-clause scrutiny. Legal advisor? Thank you, Chairman. Under 23F of the existing ordinance, the provisions are not handled in the amendment bill. The Chinese and English versions of 23F bracket C are not consistent. So I I'd like the administration to go back and see whether there's any inconsistency here. This has nothing to do with the principal ordinance, so the amendment bill may not be used to handle the problem. Well, I think the government should thank our legal advisor. If there are no further questions or follow-up issues, then the only outstanding issue is that the administration should submit a CSA. Upon receiving your CSA, we'll ask our legal advisor to see whether or not the content and drafting are satisfactory. If everything is all right, we'll not call any more meetings. So please pass the draft to our legal advisor as soon as possible. Please also pass a copy to our members, and then we'll decide whether or not we need another meeting. If members do not consider it necessary to have another meeting, that's it for this scrutiny exercise. If members are of the view that even though the amendment is simple, another discussion is desirable, then we'll call another short meeting to invite the officials to explain to us. So members, after reading the CSA, if you don't find it necessary to have another meeting, we'll report to the House Committee and then queue up for a slot in the council meeting. On the 6th of December, we can report to the HC and then go to the council meeting on the 18th of December. So, administration, if you want to proceed quickly, do act expeditiously. So thank you very much. Thank you very much, members and officials, for attending. Meeting adjourned.